Be ready? Let's start. A fair and reasonable reading of the judgment delivered by this court on August 24, 2006 in special leave petition number 4957 of 2006 makes it evident that in fact this court did not record any finding that a concluded contract had come into existence between the present appellant and the respondent number 1 herein full stop. This court noticed that on December 12, 2005 the offer made by the appellant was accepted by the respondent number 1 herein and the same was communicated to the appellant incorporating the relevant conditions for the sale full stop. It is nobody's case that those conditions, which were stipulated, were complied with by the appellant, nor any such finding was recorded by this court full stop. What is relevant to notice is that in the operative part of the judgment, this court observed that if the respondent number 3 herein makes the payment as promised within such time as might be granted by respondent number 1 and fulfills the conditions of sale, that might be the end of the matter, which means that at the time when the judgment was delivered, this court proceeded on the footing that there was no concluded contract between the appellant and the respondent number 1 full stop. Further, what is relevant to notice is that it was stipulated by the court that if the appellant failed to do so, it was always open to the respondent number 1 to take necessary steps to safeguard the interest, which included inter alia the consideration of other offers made by the other parties full stop. Such weighty observations would not have been made by the court if this court, in the said matter, had come to the conclusion that there was a concluded contract of sale between the appellant and the respondent number 1 full stop para. As this court has come to the conclusion that there was no concluded contract of sale of the mortgage property in favor the appellant of by the respondent number 1, the question arises as to whether the right to redeem the mortgage property conferred by section 60 of the Transfer of Property Act upon the mortgagor, that is respondent number 3, can be exercised or not full stop. It is argued on behalf of the appellant that both the High Court of Bombay as well as this court in the previous round of litigation had found that upon continued default on the part of respondent number 3 in making payment of amount of loan, its properties mortgaged with respondent number 1, where attached, the possession thereof was taken over legally in an action under section 29 of the State Financial Corporation Act, 1951 full stop. The learned counsel for the appellant contended that the respondent number 3 had never sought to exercise its right to redeem the mortgaged property before action under section 29 of the State Financial Corporation Act, 1951 was taken, or even thereafter till it lost up to this court on August 24, 2006 when special leave petition number 4957 of 2006 was dismissed, and therefore, the exercise of right to redeem was not only malified but also to defeat the judgment of the court. Para. According to the learned counsel for the appellant, the first proviso to section 60 of the Transfer of Property Act 1882 applies with great vigor to the facts of the case, clearly titling the respondent number 1 to apply for redemption of mortgage properties on August 25, 2006 or thereafter, and said right of redemption stood foreclosed, both by the acts of the properties and by a decree of the court. Full stop. What was stressed was that non-execution of conveyance did by the respondent number 1 in favor of the appellant was illegal, and thus, the respondent number 1 was stopped from taking advantage of its own wrong. Full stop. It was stressed that, in fact, no right to redeem the property was available to the respondent number 3. Full stop. There was not even a whisper in the said order prohibiting either exercise of right of redemption by respondent number 3 or consideration thereof by respondent number 1 in terms of section 60 of the Transfer of the Property Act. Stop.